What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly Case Update. I got 5 cases for you. Let's get right to it. First case is a DV case. It's Meredith versus Meredith. And this is a case where I think the judge went a little too far in prejudging the case and expressing his opinions on the record, which sometimes the judges do, and they really shouldn't do that. So this was a disqualification case, had to do with bias. And so basically this mom brings a domestic violence case on behalf of her child. I believe it was in Jacksonville where she brings the case because that's where she had moved to with the child. They were originally, I believe, somewhere in the Tampa area where the domestic violence had actually occurred or allegedly occurred. And so the trial judge, for some reason, was expressing himself on the record, basically saying that he thought that the mom had filed this in the wrong venue, that she should have filed it back in Tampa, and essentially like, why did you wait until you moved over to Jacksonville to file it? Sort of like saying that she did that as an advantage, to try to get an advantage in the parties' divorce proceedings, which may or may not be true, who knows. But the problem is he was prejudging the case and showing his bias. And not only that, the statute, the domestic violence statute, specifically says you can file it in the venue where you currently reside, regardless of where the domestic violence actually occurred. So the judge was basically faulting her for abiding by the statute and filing it where she currently resides. So this was a writ of prohibition. The judge improperly denied the motion to disqualify, so that got reversed. Next case is Wilson versus Herder out of the second DCA. This was a case involving 2 lawyers, basically, or at least 1 lawyer, I'm sorry. And it has to do with imputation of income. They're getting divorced, it has to do with child support. The court imputed income to the lawyer based on the median, you know how the statistics for the Federal Bureau of Statistics can have the median income for certain professions, and the child support law allows you to use those statistics to impute income. But the problem was the median income for a lawyer was around like $136,000 for a female lawyer. And the problem though was the lady here, the woman, she never actually earned that much income in her life. The most she earned as a lawyer was $106,000. So the law is clear that you cannot impute income to somebody at an amount that they've never earned unless they were recently got a degree or recently got a new qualification. So that was reversed. The other thing that was reversed is something that I think courts sometimes get wrong, has to do with the increased value of a non-marital property. So the parties had the former husband had a non-marital asset. And, I'm sorry, the former wife had a non-marital asset, non-marital home. And the way that the court calculated the marital portion of it was basically to take whatever amounts that the former husband used to essentially improve the value, I guess, but basically whatever costs he incurred for like an air conditioning unit and basically maintenance type of costs, and to pay the taxes, things like that. But the problem is, it's not just the amounts that, like the actual cost amounts that the other spouse incurs in improving the property. It's the increase in value of that property as a result of the new air conditioning unit or the whatever it is. So you really have to show fair market value of what the house was before the improvements and fair market value afterwards. So it's not like a dollar for dollar credit for the amounts that you put in on your cost basis. It's how much did it actually improve the fair market value of the house. So that got reversed. Next case is Hefley versus Colombo. This is a partition action, which happens a lot in our dissolution of marriage cases. And this one was interesting because this was another lawyer, and basically the judge sua sponte said you cannot represent yourself, nor can your husband. This is a partition action among or between 2 sisters who inherited a property. But the court said even though you're a lawyer, you can't represent yourself, and neither can your husband. And the court did this sua sponte. Basically, the court must have gotten upset with the lawyer, I guess. That was a violation of the lawyer's due process rights. And the appellate court basically said, we're not saying that the court could never do something like that, force a party to get a lawyer, even though they're a lawyer themselves. But it violated the due process rights of this party because they were not given notice. This was just sua sponte, something like that. Next case is Baumann versus Agudelo. And this has to do with garnishment of attorney's fees. So this is something big for lawyers out there if you do family law cases. A lot of times we get cases where the client may or may not pay us, or perhaps we get a judgment against the other side to pay the fees. You're allowed to garnish the wages to enforce a fee award, especially under 61.16. So you can do that. You can do wage garnishment to enforce a fee award. This was a case where basically the person appealed, but there wasn't a transcript of the hearing on the motion for to garnish for garnishment. But the reason why it got affirmed was there was no transcript. But either way, you can garnish for attorney's fees. That's something big to know about. You can garnish your wages, and you can also garnish the bank account. Last case is Secrets versus Secrets, and this is another one. This is like a too bad, man. This is too bad for this payor spouse. Essentially, this had to do with right before the alimony statute, the new alimony statute was passed. The trial concluded before the alimony statute was passed. The trial court ruled on the record before the alimony statute was passed, but did not enter the final judgment until after the new alimony statute was passed. And so the new alimony statute said, this was a short-term marriage, by the way, so 6-year marriage. New alimony statute says maximum award of durational alimony, the maximum length, is half of the marriage term, 50%. The court, in this case, awarded the full marriage term, 6 years. So this is actually good for the payor spouse, I'm sorry. Because what happened was bad for the payee, because the reason the statute actually helped the payor spouse cut off half of his alimony, the length of his alimony term. So it went from 6 years to 3 years because there was no final judgment entered prior to the passing of the statute. And the statute says it applies to all matters that are pending, still pending, and the keyword is pending, as of the date of the statute. And because there was no final judgment, this is in the 5th DCA. The 5th DCA aligned with some of the other DCAs. Because there was no final judgment ending the case, the matter was still pending, even though the court had already ruled orally. So too bad for the payee spouse. They only get 3 years of alimony instead of 6, and good for the payor. They got super lucky. All right, guys. I hope you enjoyed that. We'll be back hopefully next week. Take care.